The second time. In accordance with rules of procedure, the second reading debate is adjourned and the bill is referred to the House Committee.
This Council resumes the second reading debate on the Statute Law Miscellaneous Provisions Bill 2017. The Honourable Dennis Kwok, Chairman of the Bills Committee on the bill, will address the Council on the committee's report. The Honourable Dennis Kwok.
Acting President, in my capacity as the Chairman of the Bills Committee on Statute Law, in brackets, Miscellaneous Provisions Bill 2017, I would like to report on the deliberations of the Bills Committee. The Statute Law Miscellaneous Provisions Bill 2017 is an omnibus bill to make miscellaneous amendments to various ordinances. The Bills Committee notes that the proposed amendments are largely minor, technical and non-controversial, but are important for the purpose of updating or improving the relevant legislation. The bill comprises 9 parts, and the major proposed amendments cover 4 areas. I will not report on all the 9 parts, but will only highlight the more important ones. Firstly, the administration proposes amendments to the Criminal Procedure Ordinance, Cap 221, and the Live Television Link and Video Recorded Evidence Rules, Cap 221J. At present, under Section 79B of the Cap 221, the Court may, on its own motion or upon application, permit certain categories of persons to testify by way of a live television link. The administration seeks to add new provisions to Section 79B of Cap 221 to confer on the Court a discretion on its own motion or upon application to permit a complainant of specified sexual offences to give evidence in proceedings by way of a live television link. Besides, the bill also seeks to make consequential amendment to Rule 3 of Cap 221J, which relates to application for leave for a witness to whom Section 79B of Cap 221 applies to give evidence by means of a live television link to cover a complainant of the relevant sexual offences. The Bills Committee further notes that such permission is not automatic upon application but subject to the Court's discretion. Members of the Bills Committee have sought the explanation of a witness in fear, quote and unquote, who is already covered by Section 79B, subsection 1 of Cap 221, and the justifications for changing the Chinese rendition of witness in fear. The administration has explained that while it is possible that a complainant of sexual offences can be a witness in fear, hence be covered by the existing Section 79B, it is not necessarily so. The administration has advised that a complainant or witness of a sexual offence, though not in fear, as defined in the current legislation, ought nonetheless to be treated with understanding, fairness and dignity. Members of the Bills Committee agree that the Court should have the requisite powers in appropriate cases to protect them from the embarrassment or ordeal of being exposed to public sight, any indignity of treatment, and the anxiety arising from the need to physically face their assailants during the trial. The administration has advised the Bills Committee that by adding a new provision to Section 79B of Cap 221, where a complainant within the meaning of Section 156, subsection 8 of the Crimes Ordinance, Cap 200, is to give evidence in proceedings in respect of a specified sexual offence within the meaning of Section 117, subsection 1 of Cap 200, the Court may, on application or on its own motion, permit the complainant to testify by way of a live television link, subject to such conditions as the Court may consider appropriate in the circumstances. In response to a member's inquiry about the reason for repealing 在惶恐中的 and substituting it with 惶恐 在恐懼中的 and substituting it with 惶恐 in Section 79B, subsection 1 of Cap 221, the administration advised that the proposed amendment seeks to follow the plain language drafting practice adopted in recent years, and that the new rendition in Chinese 惶恐證人 is considered to be a more formal translation of the English word witness in fear than the existing translation 在恐懼中的證人. The Bills Committee also notes that it is also meant to make witness in fear 惶恐證人 a technical term. Referring to the proposed new Section 79B, subsection 4A of Cap 221, I've asked what are the conditions which would be considered by the court. The administration advises that the term conditions in the proposed new Section 79B, subsection 4A, is used in a broad sense. Thus, the court can consider imposing any conditions which it deems appropriate based on the circumstances of individual cases. In response to a member's inquiry on whether other measures would be available for protection of witnesses or victims who might feel embarrassed to see the accused during court proceedings, the administration has explained that other measures, such as the provision of protective screen, will be available to prevent the public from seeing the witnesses or victims if deemed appropriate by the court. A few members have proposed that the judiciary administration should enhance courtroom facilities as necessary to allow the presence of support persons who are more familiar with the witness, where a child or a mentally incapacitated person is to give evidence via live television link. The Judiciary Administration, in response, has explained that arrangement in relation to support persons is governed by Cap 221J and Practice Direction 9.5 issued by the Judiciary. Procedural fairness of the relevant court proceedings and whether the support persons has the ability and relevant knowledge to provide emotional support for the witness during the trial are some of the important considerations in assessing the above said matter. Secondly, the administration proposes amendments to the High Court Ordinance, Cap 4, and the District Court Ordinance, Cap 336, and the Competition Ordinance, Cap 619, relating to the powers and duties of temporary registrars of various ranks. The administration explains that Section 14A, subsection 3 of Cap 336 provides a temporary deputy registrar shall, during the period for which he is appointed, have all the jurisdictions, powers and privileges and discharge all the duties of a deputy registrar, and any reference in any law to a deputy registrar shall be construed accordingly. However, similar provisions are not found in Sections 37AB, 37AC, 37A, and 37B of Cap 4, and Section 14AB of Cap 336, and Section 156C, subsection 1 to 3 of Cap 619, which respectively provide for appointment of different ranks of temporary registrars in the High Court, the District Court, and the Competition Tribunal. The Bills Committee notes that the Judiciary Administration considers that despite the omission of such specific provisions in Cap 4, Cap 336, and Cap 619, it is reasonable for the temporary registrars of different ranks appointed to the High Court, the District Court, and the Competition Tribunal to be given the same jurisdiction, privileges, powers, and duties of the registrar at the respective ranks, because there will otherwise be no point in providing for such temporary provisions in the law. For the sake of clarity, therefore, the Judiciary Administration proposes that a provision similar to that in Section 14A, subsection 3 of Cap 336 be added to Sections 37AB, 37AC, 37A, and 37B of Cap 4, Section 14AB of Cap 336, and Section 156C, subsection 1 to 3 of Cap 619. Members agree. Proposed under the bill are also amendments to the Legal Practitioners Ordinance, Cap 159, and the Admission and Registration Rules, Cap 159B. The Bills Committee notes that to facilitate a better processing of application for admission as a solicitor in Hong Kong, the Law Society of Hong Kong proposes an amendment to Section 4 in brackets 1A, subsection A of Cap 159, and Forms 1B, 1C, 2, 3, and 4 of Cap 159B, so that the reference point for the calculation of the period of residence for admission as a solicitor in Hong Kong under Section 4 in brackets 1A, subsection A of Cap 159 would be changed from the date of the applicant's admission as a solicitor to the date of the application for a certificate of eligibility for admission as a solicitor. The Bills Committee has also considered amendments to the Mainland Judgments Reciprocal Enforcement Ordinance, Cap 597. The administration has explained that to maintain consistency with the English language of the English usage of the same term in the mainland, in making references to a specific level of courts in the judicial system there, and to avoid confusion of the meaning of the relevant term, the Department of Justice proposes the following amendments in the English text of Cap 597. A. The references to Basic People's Court be amended to Primary People's Court, and the references to Recognized Basic People's Court be amended to Recognized Primary People's Court. Members have not raised any issue about this. The Bills Committee will not propose any committee stage amendments to the bill. 接下落嚟啦，主席，我係想講一啲係我自己嘅個人意見。當然，我哋大家都知道咧，呢啲咁樣嘅法律條文呢係必須需要改革，亦都係咧法院呢係要與時並進。我哋樂見呢今屆施政報告呢係行政長官有講到就係將會有一個
And the courts must move ahead of the times. And there's a $20 billion fund for courts to build 2 new court buildings. One will be next to this electrical complex, the new High Court building. Another one will be in Causeway Bay, a new district court building. This is important to our judiciary because we need the hardware. And the current capacity is already reached. The current High Court building is so well utilized that even if we appoint 7 High Court judges which have been left vacant, we don't have enough courtrooms. And where juries are required, or where a court case will require the presence of many lawyers and witnesses, we don't have the space for them. We understand the importance of hardware, but hardware in itself is not sufficient. And we should also pay attention to the matter of the laws and whether the laws are being updated. So this is not just a concern for the legal sector, and this is equally a concern to many people. If the law reform progress is so slow, we need to, if there are many laws which are not updated, when they have to be updated, then our status as a group, as a leading hub for legal dispute resolution will be called into question. So I hope the new Secretary for Justice will look at the pace of law reform, apart from the recommendations of the Law Reform Commission, which I think should be followed up by the government immediately. And we also have to look at the system of law reform so that we can make it more professional, and we should have a sustainability in the work of law reform, and we should have the capacity to engage full-time researchers for law reform. Many people compare Hong Kong with Singapore because Singapore is moving ahead much more faster. There's no doubt that they are doing a better job than Hong Kong. So in order to enhance our competitive edge and to enhance our status as a legal hub, law reform is very much needed. And now we are talking about this reform on statute law. It represents a small step, but yet it's an important step. When it comes to the rule of law, we need to have quality judges. We don't have anyone from the judiciary today, but we all know there's a shortage of judges and judicial officers. Their workload is very high, and many lawyers are deterred from joining the judicial offices. There are many vacancies, but many people are reluctant to join the court. According to some judges, they have to work 6 to 7 days a week, and yet the judgments cannot be handed down or written in good time and handed down in a suitable time frame. It's because of the backlog of cases, and also the listing time has seen no improvement, which is worrying. If the cases cannot be disposed of in good time, that would also deter people from choosing Hong Kong as the jurisdiction for the resolution of legal disputes. So there's a shortage of judges, and the judiciary, of course, would like to recruit the best people to become judges. And recently, the Court of Final Appeal has 2 new judges, very senior judges, appointed to the bench of the CFA, which is something we would like to see. This council is going to set up a committee to look at the appointments. We have a group of very qualified and experienced CFA judges, which is very good. But in our magistracies and district courts, we also need good judges and judicial officers providing the service. We have discussed this as our AJLS panel. One of the suggestions is to change the retirement age from 60 to 65 or 65 to 70 as appropriate, so that qualified lawyers are more willing to join the judiciary. For these people will not be doing this for money. Money alone would not be able to attract quality candidates, but it's the working environment, the social status, and whether they can contribute to the community through such roles will be important. Many people have cast doubts on whether the judicial system is still sound because of the MPCSC interpretations. I would say that the rule of law in Hong Kong is still very robust, but many a time we have interpretations by MPCSC that casting a shadow on the judicial system. That's why we are saying that the interpretation by the MPCSC should not be resorted to lightly. It should only be done when it's absolutely necessary and when there's a need to interpret relevant laws. Madam Deputy, I don't want to dwell on this matter for too long, because this bill before us is a technical bill and is straightforward. I just want to say something about the current status of the rule of law in Hong Kong. So I submit.
Does any other member wish to speak? Before I ask Dr. Elizabeth Quat to speak, I must remind members that we are now having a debate on the Statute Law Miscellaneous Provisions Bill 2017. And I hope that members should not digress too far to talk about the judicial system in Hong Kong. Let's focus on this piece of bill, please. Dr. Quat. I speak in support of the Miscellaneous Provisions Bill. And it has to do with amendment of the Criminal Procedures Ordinance Cap 221, live television link and video recorded citizens rules Cap TT1J to confer on the court to allow victims of sexual offences to make a witness through television live link. Since 2012, I've been following on how to help victims of sexual offences so that they would not be subject to secondary harm. I've strived for all kinds of opportunities to do that. We meet with the judiciary and etc. So for every meeting, I would like to voice out on behalf of the victims of sexual offences. Earlier, I have strived for them to give a witness behind protection screens, and they can also give evidence through live television link. Now, I raised this issue first in 2012 at the AJLSB. Some seasoned lawmakers told me that they have discussed this subject matter for 1 to 2 times already. They think it's very difficult. It's not easy at all. But I can't imagine that I could spend 5 to 6 years to convince the administration to amend the ordinance. I must tell the public that why we are so concerned about this amendment of the bill, and why do we have to voice out for victims of sexual offences. Normally, they are in the a small group of people for sexual offences which actually have gone into the court. The number is very small. When victims of sexual women are suffering from sexual offences, they suffer psychologically and physically. As to whether the victims will report the case to the police and take the case to the court, the victims have to struggle psychologically, and they face tremendous difficulties. One of it is they have to recount their experience towards a stranger or even the public at large. They have to share their experience. And the victims may feel ashamed of themselves, and they may feel helpless. They may be in fear, and they fear that they will be identified by the public, and they will be discriminated against, and they will be subject to further hurt again. Now, the victims may go through a lot of unhappy experiences once they've decided to report the case. Many organizations helping these victims have approached lawmakers and share their cases with us. And we know that starting from the early days, these victims may see the social workers and the NGOs, but ultimately they decided not to report the cases to the police because they were in fear. And if they decided otherwise, they would have to go through another unhappy or painful experience. At the police station, they had to repeatedly share their experience again. Then people would doubt whether they were speaking the truth, and they have been taking a proactive role in their experience, and they have to have their injury examined and so on. So these are this was very painful for them. And at the court, the victims told us that they got the feeling they were indecently assaulted and raped once again. Why? If they had to give witness in the court, from the minute that they stepped into the court, they felt that they were unprotected. For cases involving such sexual offenses, you will see that the courtroom was always filled up with people. People were curious, so they were sitting in the courtroom. So many people were standing in the waiting area, queuing up to enter the courtroom, and the victims had to pass through this crowd of people, and they would be commented upon by this observers. And if the victims were not children or mentally incapacitated people, if they had to apply for giving witness behind protection screens, that was difficult, to get. And it was also impossible to give evidence via a live television link. So without any protection in the court, they had to recount their experience once again. And a lot of members of the public would keep on commenting on the case, and so they were hurt again and again. So we hope very much to strike for the interest of the victims of sexual offences, so that they would not be hurt again, and as a result, they would be more willing to come forth to report the case and give witnesses. And the giving of the witness can be done under some protected measures. But regrettably, within the electoral and also in the community at large, there were a lot of seminars held on the subject matter, But then there was great resistance towards achieving that, and now we have come to this stage, and I'm very happy. It was very difficult, and earlier we have strived successfully for the court to use its discretion to give evidence behind the screens, and today, the victims of sexual offences can give evidence now via a live television link, and this is a major stride that we have made in protecting victims of sexual offences. Given this is the first step, I hope that many more victims can come forth to report their cases to the police, and they could give evidence under less pressure. So does it mean that all the problems have been solved now? Madam Chair, as I said, and also as pointed out by Mr. Dennis Kwok, many of the facilities in the court, the hardware have become outdated. Apart from giving evidence behind protection screens and through live television link, I believe that the victims should be given even more protection. Say maybe a special passageway can be made available for them, a special waiting room, perhaps also, and maybe someone familiar to them can accompany them when they are giving evidence. And I think all these are important. And some organizations told us that earlier the police had published tens of thousands of publicity leaflets on giving evidence behind protection screens. But many victims have not received such pamphlets, and they are unaware of their right. And every time they have been told, they would have to be told that they could give evidence behind screen. But even if this is the case, they still have to pass through the crowd and the waiting area. There is no special passageway for them. I hope that improvement can be made. And now victims can give evidence through live television link, but do the victims know about them? Will the government step up its publicity? Will the government publish more publicity leaflets, not only in Chinese and English languages, but also in other languages as well, so that the victims are made aware that they have the right to apply to give evidence behind screens and via live television link, so that they would not get nervous when they give evidence. I am very happy that we had the chance to discuss this and endorse this amendment today. But then there are those who are mentally incapacitated, who are victims of sexual offense. I think there isn't enough protection for them under the law now. I know that there will be further discussions in this regard in the future, and I hope that that there will be many more such amendments introduced to the Council, and we can pass these amendments expeditiously to give better protection to victims of sexual offense, and they will be given a fairer judgment or ruling.
Honorable Holden Chow. Thank you, Madam Deputy.
Madam Deputy, this statute law miscellaneous provisions for 2017.
Different legal measures and changes to them are included. I call these updating and aligning them with present times. For example, the naming of mainland courts in our statutes, and also, as Ms. Elizabeth Quat said, which is also the concern of many citizens, and that is witnesses in fear and how they will be able to give evidence by way of a live television link in future. All these are included in the Statute Law Miscellaneous Provisions Bill 2017. I support all these, and I'd like to speak my views here on allowing witnesses in fear to give evidence by way of live television links. I'd like to say here that we are of the view that this can protect victims and witnesses of sexual offenses. They will be able to find justice, and the relevant arrangements can actually be improved. As a practicing lawyer, I have the responsibility to tell the public that actually some time ago there was this incident of the Cambridge Home for the Elderly. A sexually incapacitated person was unfortunately sexually assaulted. But since, as the legal sector would say, hearsay evidence cannot be accepted for a criminal case, and perhaps we should say, therefore, that the victim in this case could not seek justice. And I also have the responsibility here to say something about reform to hearsay evidence. This has been talked about for many years, and the Legal Reform Commission has done a lot with regard to the admission of hearsay evidence in criminal cases. I'm happy that the administration responded to this. At the AJLS panel in February, the reform of hearsay evidence, including the intentions for change and also the public consultation exercise, all that has been reported at the panel meeting. I hope the hearsay evidence reform can go on and for it to be implemented effectively in Hong Kong. Madam Deputy, in many different common law jurisdictions, there has been reform with regard to the admission of hearsay evidence in criminal cases. Some places have actually accepted it with restrictions. I can see that in many common law jurisdictions in the world, certain arrangements have been put in place. And for the sake of the audience watching our live broadcast, I hope they will understand what is meant by admitting hearsay evidence in a criminal case. If a person cannot eventually be questioned in court, even if he has given evidence in writing, the evidence will not be admitted. In simple terms, you must be questioned in court to make sure there is a fair trial. This is a common law principle, Madam Deputy. As a member of the legal community, of course, we understand that very well. But as Ms. Kwat said at length just now about the historical background, victims of torture or sexual offenses, if they have to be questioned in court, it will pose difficulties for them. And if this proves to be a hurdle, so that their evidence, which is regarded as hearsay evidence, will not be admitted by the court, and if therefore justice is not done, now I would find that very unfortunate and pitiful. I like therefore to state my view here that I would like the administration to continue to pursue the admission of hearsay evidence in criminal cases. I hope the reform can continue. Madam Deputy, With regard to this statute law miscellaneous provisions bill, as I said at the outstart, many of the changes have to do with judicial measures and even judicial facilities. I'd like to take the opportunity here to briefly say that with regard to the manpower situation in the judiciary, I think I have the responsibility to speak on it. For a very long time in the past, I have asked for the Small Claims Tribunal to enhance its maximum amount that can be dealt with at the SMT, and that is from 50,000, upgrading it to 100,000. So members of the public can seek compensation without legal representation, and more people will have justice done. I'm happy for the administration's response. A Bills Committee has been set up, and I am the chairman of that Bills Committee. We are now scrutinizing, enhancing the maximum amount that can be dealt with by the SMT, first of all, from 50,000 to 75,000. I'm happy for that response, but I also have the responsibility to mention that the administration should also cautiously examine manpower complement for SMT. If the amount is enhanced, the SMT may need more presiding officers and other manpower because cases might increase. I hope the judiciary will make an appropriate assessment. It is important to have support staff for the SMT. Now, at the district court, you will be legally represented and all the legal points will be taken care of. But at the Small Claims Tribunal, or SCT, since there will be no legal representation, the legal points and the case must be prepared by the presiding officer. Otherwise, the presiding officer will spend a lot of time understanding the case. In order that the public can process the cases more speedily, we need to supply the SCT with sufficient supporting staff. I hope the administration will hear us to give more protection to the public and also facilitate the public making use of the service of the SCT. Last but not least, Madam Deputy, since a member mentioned the rule of law situation and the judicial system in Hong Kong, it was said that our judicial system has been hurt by interpretation of the basic law by the NPCSC. Allow me to say that I differ from Mr. Dennis Kwok, that our rule of law is damaged by the interpretation of the basic law by the NPCSC. I hope the public will have a discerning eye. Ever since reunification, the NPC has exercised restraint in interpreting the basic law, except in absolutely necessary situations. The last interpretation was about oath-taking. Well, you understand what it was about. It is because someone chose to add to the oath by resorting to near insults to damage the dignity of our own country. And someone actually openly incited separatism. And that is why the NPC had to take action to take care of oath-taking by interpreting the basic law. I hope you understand that this is not just about a case, but this is at the state level. It has to do with territorial integrity. From the angle of the country, someone has made use of oath-taking at the council in order to spread the message of separatism. I think that should not be tolerated. I hope the public will understand that that is the background to the NPC interpretation of the basic law. If any member should say that that damages our rule of law, well, I like to refute that argument, and I hope the public will understand that we should not resort to such remarks in order to cover up the acts of damaging one country, two systems. Thank you.
Once again, I would like to remind members that we are having a debate on Statute Law Miscellaneous Provisions Bill 2017. I allowed Mr. Houghton Chow to respond to the views expressed by Mr. Dennis Kwok, but I hope other members would just focus on this bill. Does any other member wish to speak? If not, I now call upon the Secretary for Justice to reply. Then the debate will come to a close. Secretary.
Madam Deputy, first of all, on behalf of the Department of Justice, I would like to thank the Honourable Dennis Kwok, the Chairman of the Bills Committee of the Statute Law Miscellaneous Provisions Bill 2017, and other members of the committee for their hard work in completing the scrutiny of the bill. I'm also grateful for their valuable advice. As the former SJ pointed out when introducing the bill into this Council in June last year, its objective is to make minor amendments that are largely technical and non-controversial to various ordinances to update or further enhance the relevant legislation. The proposed amendments in the bill fall roughly into 4 categories. The first category of amendments are those proposed by the DOJ as set out in Parts 2, 6, and 7 of the bill. The second category are those proposed by the Judiciary Administrator as set out in Parts 3, 4, and 8. The third category, proposed by the Law Society of Hong Kong, is set out in Part 5. The fourth category, in Part 9, concerns miscellaneous and technical amendments. I will now introduce the various amendments. Of the amendments proposed by the DOJ, Part 2 concerns the Criminal Procedure Ordinance, as well as the live television link and video recorded evidence rules. The current amendments will give the court discretion to permit complainants of specified sexual offences to give evidence in relevant proceedings by way of a live television link, subject to such conditions as the court considers appropriate in these circumstances, in order to enhance protection for such complainants. I'd like to thank Ms. Elizabeth Quat for her concern and care and support towards victims of sexual offences, and so that this bill receives support across the political spectrum. Part 6 of the bill amends the English text of the mainland judgment's reciprocal enforcement ordinance by replacing the references to basic people's court in the mainland therein by primary people's courts, so as to maintain consistency with the English usage of the same term in the mainland, thereby avoiding confusion of the meaning of the relevant term. Part 7 amends the Legislation Publication Ordinance and the Law's Loose Leaf Publication Ordinance 1990 to enhance the efficiency of law's compilation and editorial amendment work. As regards the amendments proposed by the Judiciary Administrator, the key points are as follows. 1. Part 3 of the bill clarifies the powers of temporary registrars of different ranks appointed to the High Court, the District Court, and the Competition Tribunal. The amendments will make it clearer that temporary registrars appointed to such courts and tribunal will be given the same jurisdiction and powers of the registrars at the respective ranks. Two, Parts 4 and 8 of the bill amend the District Court Ordinance. Amendments in Part 4 provide for representation of the SJ at the District Court Rules Committee, while the amendment in Part 8 aims to make it possible for the jurisdiction limit of the amount of claim for costs in costs-only proceedings to be amended by resolution of the Legislative Council. Both amendments aim to align the practice in question with other similar arrangements. Part 5 of the bill clarifies the reference point for the calculation of the period of residence for the purpose of admission as a solicitor in Hong Kong at the suggestion of the Law Society. With this amendment, the reference point will be set at the date on which the person applied for a certificate of eligibility for admission, rather than the date of the applicant's admission as a solicitor. In other words, the applicant is required to have resided in Hong Kong for at least 3 months immediately before the date on which the person applied for the certificate. The last category of amendments in Part 9 contains miscellaneous and technical amendments to various legislative provisions for the purpose of refinement. I will be moving committee stage amendments later to amend clauses 1(2) and (4) of the bill. We wrote to inform and consult the Bills Committee about the CSAs on the 14th of February 2018. We are given to understand that members have no objection to the amendments. Clause 1(4) of the bill provides that Division 52 of Part 9 of the bill is to come into operation on the 15th of December 2017. That division amends sections 12 and 13 of Part 5 of Schedule 2 to the Airport Authority Bylaw, Cap 483, Sublet A. Those amendments are consequential upon the amendments made by LN 63 of 2017, that is the Road Traffic Control Amendment Regulation 2017, to Section 52 of the Road Traffic Control Regulation, or Cap 374, Sublet G. The commencement date provided in Clause 1(4) of the bill was set with a view to aligning with the commencement date of LN 63 of 2017, which also came into operation on the 15th of December 2017. The original commencement date has passed, and Division 52 of Part 9 of the bill is not intended to have retrospective effect. We therefore propose to amend clauses 1(2) and 4 of the bill to the effect that Division 52 of Part 9 will come into operation on the date on which the Statute Law Miscellaneous Provisions Ordinance 2018 is published in the Gazette. President, I'd like to thank the two members for their speeches. Perhaps I'd like to respond to those briefly, especially with regard to points made by Ms. Kwat. Ms. Kwat mentioned witnesses of sexual offenses and whether there will be a particular passageway for it. On the 28th of March, the judiciary sent out amendment directions to stakeholders, including the DOJ, allowing witnesses of sexual offenses and other vulnerable witnesses to have better protection when they give evidence in court. The practice directions state that in every case of sexual offense taken to court, there should be consideration of using a special passageway, or for the particular people to be supported by a supporter or accompanied by a supporter. This will become the routine procedure. Other views stated by the member will be related to the judiciary. As for Mr. Chow's point on hearsay evidence and the process for amending it. We are actively pursuing it, and in due course, we will come back to the Council. Madam Deputy, with these remarks, I urge members to support the second reading of the Statute Law Miscellaneous Provisions Bill 2017 and the CSAs that I will move later. Thank you, Madam Deputy.
I now put a question to you that the Statute Law Miscellaneous Provision Bill 2017 be read the second time. With those in favour, please raise their hands. Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. Statute Law Miscellaneous Provisions Bill 2017. Council now becomes Committee of the Whole Council.